And Mr. Smolford, let me ask the appellees, are you all dividing time or is one person speaking?
We are dividing time well,
How are you dividing it?
splitting it evenly.
Okay, so who will be arguing? Who will be arguing?
Mark Peoples and Susan Stevens.
Very good, thank you. Mr. Smolford.
Yeah, please support. I'm David Smolker. I'm here on behalf of Dr. James Laws III, who's the appellant in this case. He's a longtime resident of Seattle, in Sarasota County, and he is here with us today, sitting next to the gentleman with the blue suit, along with Mr. Ralph Brooks, who's co-counsel in this case. Your Honors, this appeal presents a significant issue. The issue is whether or not individuals who reside on barrier islands, who are uniquely situated and essentially have only one way on and off the barrier island to get to the mainland in order to serve their daily needs for services, as well as medical services and hurricane evacuation, should have standing to challenge a decision by the Department of Transportation that will cause significant deterioration of the safety and operational characteristics of the road that they depend on. In this particular case, Dr. Wallace filed a petition for formal administrative hearing under Section 12057 Florida statutes under the Administrative Procedures Act. The focus of the case was on the northwest corner of Stickney Point Road, which is the road that he depends upon to get to and from Siesta Key, the mainland. A large development was being proposed at the corner of US 41 and Stickney Point Road. And in connection. Yes.
Can I just jump ahead, because there's something I'd really like to get clarified. Is the problem the connection, or is it the traffic light?
It's both, and the two are inseparable, both factually and legally under the Florida Transportation Code. As we've outlined in our reply brief, what you have here is a code that has been adopted by the legislature that governs the Department of Transportation's regulatory authority, which extends both to issuance of driveway connections upon application, as well as traffic signalization that may be associated with that. And in fact, if you review 1496 citation, I don't have it handy, but their own rules require that traffic signalization be considered as part of a driveway connection application. And so because the code is supposed to be a unified code, all the provisions relating to traffic signalization and driveway connection have to be looked at in a holistic, unified way. And you can't separate them out as the applicants would like the court to do, as if they can be viewed in isolation, because they can't as a practical matter. And as so the Department of Transportation had issued a notice of intent to issue this driveway connection permit, which included at the applicant's request a traffic signal that was going to be located essentially in a spot between US 41 and Siesta Key. Now, notably, and I would direct the court's attention to pages 69 and 70 of the record, the DOT had previously identified this particular intersection and link as being a traffic safety problem, and also a intersection and roadway that was operating at what's called level service F, which is a transportation engineer's way of saying the road is failing. And in this particular instance, the department literally sent a letter to Sarasota County saying, hey, you guys need to be careful about what you include at this location.
So that's been approved. That's not before us.
This is true.
Okay, so let me ask a question.
Yes.
That goes to the standing issue. How is your client impacted in a manner that is different from anyone who travels the intersection? I understand he lives on Siesta Key and that has its own problems, but isn't the impact of that traffic signal one that impacts anybody on those roads?
If we're talking about US 41,
Yeah, and I know US 41, I know Stickney Point Road, I know Siesta Key, It's a bad road and it has been a bad road, and unfortunately it will continue to be a bad road.
See, the difference here is that Dr. Wallace lives on Siesta Key.
As do thousands of other people.
True. But the fact that there's thousands of other people that live on Siesta Key should not be what is dispositive of whether those individuals would have standing to challenge a decision that adversely affects their ability to get on and off Siesta Key. And in fact, there is a case, admittedly it's in dictum, but it's the case of Friends of the Pandas, the Department of Environmental Protection, 729 Southern 2nd 437 50 CA 1999. That is the only case that I could find where specifically standing under Chapter 120 was at issue in the case of a barrier island. Now, in that case, the challenge was to the DOT constructing sewer lines along the roadway that was their sole point of access to and from the mainland. And they were challenging it because they didn't want to see more growth occur. And the court basically said that doesn't fall within the zone of protection in this particular instance. But it did say in dictum, and it impliedly held, that beach residents on barrier islands do have third-party standing under Agrico, where their ability to evacuate in the event of a hurricane would be affected by that DOT road project. So we also have other examples where I think the way the law distills down, based on my research, is that we do have examples, which were cited in our brief, of where the DOT made decisions with respect to the state roadway highway system, and they were challenged by environmental groups or individuals. And the courts have consistently said in those circumstances that they do have standing. Admittedly, it's a little different factual circumstances than ours, but the principle of the APA is that it was intended to liberalize standing such that the traditional bars to access to the courts and to administrative proceedings were liberalized so that the general public, if they're substantially affected, would have the ability to be able to participate in the formulation of final agency action by state agencies. Dr. Wallace was denied that in this particular instance.
I'm going to say one other question, because in your brief, you had said a couple of times that this is virtually his only access road to Siesta Key. Is the northern access point closed?
No, it's not, but he lives 4 miles.
I understand it's not easy to get on and off at either point, but I was worried that perhaps the northern road had been closed down for some reason based on your brief.
No, it has not been, Your Honor. It's there, but I think as a practical matter, it doesn't really serve Dr. Wallace well in the event of an emergency. To have to go that much farther. Plus, I think the record would reflect the fact that the congestion out there wasn't just Stickney Point Road. It extended all the way to Midnight Pass Road, and that intersection in and of itself was highly congested.
Which existed before this became an issue.
I believe that that's true.
Well, we don't reach the ultimate merits as far as traffic and congestion, because this was decided on a standing issue.
Right, and that's the point. So the whole purpose, one of the purposes of the APA is to give due process to substantially affected persons. And we adequately pled that the injury that he suffered was particularized under Agrico, and that it was clearly within the zone of protection of this regulatory scheme. And ultimately, the DOT, I think, postured their legal position as one of, no, you just don't have any rights challenge DOT decisions with respect to traffic signals, almost as if they're immune from judicial review on that. And the order that they entered simply never really actually gets to the heart of the matter which is what's the effect on Dr. Wallace? And the pleadings were more than adequate to show that he had a particularized interest in being able to get on and off Siesta Key in his best of circumstances. And that
And the
exactly.
department also concluded that, at least to some degree, those interests were speculative. I thought there was something in there about how a hurricane would impact getting on and off because of the flight would be speculative.
Well, the answer to that question is, I don't know off the top of my head whether they said it was speculative, but that's really not what's at issue. That would be if you went to a hearing and we had the opportunity to put on testimony and evidence of a particularized injury, and it turned out it was speculative, then I could see that you did not stand. But what we pled was sufficient. So I think the key here is that the allegations of the amended petition were more than sufficient to satisfy Agricode, and therefore we should have gotten a formal administrative hearing and an opportunity to show why the decision to allow this particular driveway connection, which incidentally, at this particular location and this particular driveway connection that is going to be signalized prior to the approval, there was 422 cars per day that would come on the Sticky Point Road at that location before the traffic signal and the access connection. By the applicant's own application, they did a traffic analysis and it showed that the number of average daily trips that would be coming to this intersection would be over 6,600. So we have a 1,500% increase in the amount of traffic that is going to be placed onto Sticky Point Road at that particular location on a roadway that is already suffering, as Judge Silverman pointed out, from severe congestion.
So you're saying that any time a traffic decision and traffic planning decision is made, that will add to congestion, make traffic move more slowly, there's an injury in fact of sufficient immediacy?
No, I would not contend that, Your Honor. What I would contend is if that injury is particularized and different in type and degree than that which would be suffered by the general public as a whole, then there would be standing under these unique circumstances.
So what if I worked on Siesta Key? And so 5 days a week, I'm going back and forth. Do I have standing under your approach?
I think you could have standing, yes.
Okay,
I
but
think-
I wanted to work on my tan, so I'm going to the beach, obviously on it, 3 days a week.
I would argue that there is a fine line to be drawn here. I would say in that circumstances that the interests were not so substantial as to be able to provide a basis for standing under it. However, if you live there and you reside there and you depend on the roadway for your daily needs and for medical services, and it could be the difference between life and death. Because if those emergency vehicles can't get to you in time.
But that's true if I'm on the beach working on my tan or if I live there.
This is true, except that the probabilities of that kind of harm occurring to somebody who's out there to get a suntan, I think are relatively slim. Whereas in comparison, if you've got an elderly person who resides in Siesta Key, that is a big difference.
Okay, so what about the person who works on Siesta Key? You're saying the one who lives there clearly has standing, the one who works on their tan clearly doesn't have standing. The person who works 5 days a week, it's a closer question. Is that sort of the?
Your Honor, I'm not so sure it's could say clearly when we're talking about somebody that's working there. I think I can make a case that they would have standing, that their interests are different than that of the general public, especially the general public that's just going there on occasion. So I think the important thing to remember is to put it in perspective. And in perspective, the whole purpose of the APA was to give substantially affected persons an opportunity to participate in formulation of agency action. they still don't get to control it. They just get to have provide feedback. And in this particular instance, it's sort of the convergence of the perfect storm of problems that are created from a traffic safety and operational standpoint that Dr. Wallace is essentially being sort of thrown the rules away.
Mr. Smoker, you're at the 5-minute mark if you wish to reserve the rest of your time.
I would be honored, and we will rest on the briefs, and we appreciate it, of course.
Very good. Thank you very much.
Good morning, Mayor, please report. I'm Mark Peters for the Board of Department of Transportation. With me at council's table is Susan Stevens. Ms. Stevens represents the permittee CF 41. The court's already developed that the Agrico test for standing is 2 prongs. Conveniently enough, we have 2 lawyers, so I'll be addressing the first prong of injury in fact, while Ms. Stevens will address the zone of interest prong. Our fellow lives about 4 miles away from this traffic light. He alleges that this traffic light will cause him to get stuck in additional traffic. That's not an unflattering paraphrase. The court's read the briefs, it's familiar with the record. That's literally what he says. We'll get stuck in traffic. And the question for this court is whether getting stuck in traffic is sufficient to confer standing to challenge the department's decision to grant an access permit to this CS 41's development.
Well, I think the other concern, I don't think it's quite that simple. I think the other concern, for example, emergency vehicles. And to the extent that the entire permitting scheme is supposed to take into effect, public health and safety, how is that not a valid concern? And a valid an injury in fact of sufficient immediacy.
That it will affect the emergency vehicles because it affects everybody the same way. The court's already discussed that with my counterpart on the other side, that there is no right, there is no legal interest in traffic flow. There is no legal interest in favorable traffic conditions. This court has held that a substantial interest must be based upon legal entitlement, not a unilateral expectation. He may expect for traffic to be favorable, but nobody's entitled to favorable traffic conditions.
One of the questions I asked a moment ago was dealing with the speculative nature of an injury, and the test, and that may not be the best wording that I chose, but the test is will suffer injury in fact, which is of sufficient immediacy. And so the question that I go back to is, where does the speculative nature of that come into play? Whether it is of sufficient immediacy, or do we potentially have to look at, we know access is going to be more difficult by virtue of an added signal in this area, or at least that's the allegation that it will be. And we have not tested the merits of that.
That's true.
So how does this tie in this? Is it of sufficient immediacy? Or it could happen, he might never need an ambulance, he might never need a fire truck. How does that play in?
I think that it's fair to say that the allegation does have a degree of speculation to it. It could happen, it might not. And because concrete harm is required, I think that is a valid point to make, that on that basis alone, they failed to allege a substantial injury. Your honor is quite right, though. They are required to accept their allegations as true, and so we have to accept that the traffic light will cause additional traffic. I think that my counterpart conceded that in his presentation that what's really causing the additional traffic is the development itself. And as your honor has pointed out, what Ms. Stevens wanted to discuss when she gets up here, that's simply not before the court. They have
If this case ultimately got to the merits, the appellees may be able to establish that traffic flow would in fact be enhanced by a better controlled intersection and better controlled access to the intersection. And so ultimately the question is, who gets to test that? Is that purely a planning decision by the department, or is there administrative or judicial review of that determination?
Traditionally, yes, it is purely a planning decision by the department. We've developed this in the brief at some length that in these types of situations, discretion must be placed somewhere. And the legislature, widely or not, has placed it with my client. And so, returning to the question of injury, in fact, a person does not have, this is the Ferry v. City of Gainesville case, a person does not have a right to require the state to maintain the traffic schedule at any given time or place. I think it follows from there that a person does not have a right to prevent the state from installing a traffic signal at a given time or place. I argue Ferry in the answer brief. I reread the reply brief. I don't believe that they've ever addressed the point of Ferry. And I've been curious to hear what the appellants have to say about it, because it'll be the first time I've heard anything about Ferry. I'm inclined to yield the rest of my time to Ms. Stevens unless the court has any further questions for me.
Thank you very much.
I urge the court to refer. Thank you.
Today seems to be the day for appellees to yield time, which we talk about in seminars regularly.
Good morning. My name is Susan Stevens. As Mr. Peoples indicated, I am with the law firm of Stearns Weaver Miller, also representing appellee CS 41 is Steve Brannick, who's seen before. Again, we represent appellee CS 41 Associates. They are the permittee that DOT proposed to issue the driveway connection permit for. I'm here to talk about the second prong of the Agrico case. The Access Management Act is simply not designed to address the traffic coming from the underlying development. It's really a case about traffic congestion on this road. The record is clear in the allegations in this amended petition. It's at 31 through 34 of the record. That it's the additional traffic congestion, whether caused by the light or the 6,653 cars. I think the appellate counsel referenced in his argument. It's those extra cars on the road that are his complaint, and for three reasons those are not within the zone of interest. First, there is the Access Management Act has a narrow statutory framework. It is not the broad public safety, health, and welfare. It is narrowly the connection permit process, permitting of access points on the highway. Second, the appropriate forum here to talk about the volume of traffic on the road is with the local government as part of their traffic concurrency with Sarasota County. And third, that forum has already been utilized by appellant. He appeared before the Board of County Commissioners. He orchestrated, the record reflects, he orchestrated the appeal to the circuit court, and the record reflects that traffic congestion and the signalization of that intersection were heavily discussed, both before the Board of County Commissioners, before the Planning Commission, even before that, and then in the circuit court, and this court denied second cert review in this case. So the scope here, the purpose, the specific purpose of the Access Management Act in 335-181(2) is to provide the right of abutting owners to reasonable access, not unlimited access, but reasonable access to a state highway, in this case, Stickney Point Road. It is not, conversely, opening up to all drivers on the highway and their access, because this is really about his access 4 miles away on a non-abutting portion of Stickney Point Road, leaving and coming back to his home. Rather, coordinated planning process for the permitting of access points. Access points. The statute in turn defines connection when it's talking about what is taken into account in this process. 335 182(3) defines connection to mean the driveways, the streets, the turnouts. They're not talking about the features like traffic lights that are in the right of way. They're not talking about the road congestion. To the extent that the Department of Transportation does consider and include traffic in its evaluation, it's for the structure and design of that driveway connection. That is defined in the department's rules in 1496. Turning movements, turning radii, channelization. Do you need a right turn only lane? Do you have enough trips leaving and turning right that you need a right turn only lane? Does it need to be full access given the number of trips, or does it need to, or is there going to be limited to a right turn only lane? Or do you have to have all of the different lanes of traffic?
So let me ask you, if Dr. Wallace had alleged, I'll be coming, I live on Siesta Key, I'll be coming from that direction. As I turn into the development, given how this connection is designed, it's going to be inevitable that there's going to be a point where I'm going to be, in the path of oncoming traffic or something like that, and therefore it's inherently dangerous or something like that. Is that the kind of thing that you're talking about?
Yeah. Your Honor, yes, indeed. In fact, I do think it'd probably still be problematic for him to prove a particularized substantial interest being 4 miles away on a non-abutting road, because the design of the connection seems to be more likely significantly focused at that intersection. But yes, it's the use of that intersection, the design of the ingress and egress out of that connection that is an issue. And to that point, I need to turn back to Friends of Matanzas, because the appellant has miscited it in his brief and miscited it here to you today. There is no dicta that third party, that residents on the barrier island might have standing to challenge a traffic decision of the Department of Transportation. This case was about the decision to install sewer and water lines to a rest area on I-95. And they said, the court said, they expressed sympathy for petitioners that who feared that extending those sewer and water lines would lead to further development on the barrier island that would in turn cause greater population there and make hurricane evacuation difficult. But they said sewer lines had nothing to do with that. And he said, the court actually said they felt, had sympathy for the petitioners because the expansion of the water and sewer lines fell out of the possible development order challenge at the local level. But the court cannot provide a remedy where the legislature chose to do so, where the legislature chose not to do so. And there simply is not a remedy for a resident on a barrier island to challenge the connection in this case, without at a minimum, Your Honor, alleging the actual use of the connection and that use would be made more dangerous. For example, it was currently a 3-legged intersection. Maybe it used the avenue B and C, and that would be made more difficult. I'm not sure how we would make that allegation that it'd be made more difficult by it becoming a 4-way intersection. But that is possibly, Your Honor, that could possibly be the case. And again, 335-184-3 that they cite a lot in their brief about the factors on which you can deny a connection permit are focused again on the connection as defined in statute, that the safety and operational effects are focused on the effect of the connection and permanent turning movements only. That is what DOT's access standards and rules are to be focused to. The connection statutorily defined to the driveway, the turning, the road, the actual item coming into the road, the roadway coming into the state highway, and the permanent turning movements associated with that. And so, and to that, that's why the department has established rules saying what do we mean by that? The operational characteristics of that turning. What are the turning movements? And again, it's those design and engineering features of that connection point that we're actually referring to. And again, the appellant has already availed himself, as we've all recognized, he's availed himself of those Sarasota County proceedings below. He participated, he didn't like the result, and is trying here again in a much narrower proceeding to try again to complain about the additional traffic, the 6,600 and some trips that the underlying development will cause. And this is simply not the forum. The Palazos-Los case makes that clear, that where you can bring something in circuit court, a circuit court appeal of development approval in that quasi judicial setting, that's where you need to go. It is not in this much narrower appeal of a driveway connection permit. The driveway is not adding the cars to the road. It is the underlying development. The driveway is not having the effects he's complained of, even if they were not speculative or suffered by every other driver using that road. Any other driver using the road, regardless of where they're going, is going to be stuck in the same amount of traffic. And to your Honor's point about the speculative nature of the claims, he states that the probabilities, because his client is old, or older, sorry.
Yes.
The probabilities are higher that he might need an ambulance. And that's simply far too speculative under Jerry, the Office of Insurance Regulation, Village Mobile Home Associates, all of those indicate those are far too speculative types of injuries. Near congestion is something that every driver on the road suffers, regardless of how often they use the road. Any additional effects that you claim that result from that are necessarily speculative and conjectural and not an injury of sufficient immediacy. In summary, waiting in traffic is not the degree of injury needed. Every driver has to wait. There's no right not to wait, merely a unilateral expectation, as this court is recognized in Carroll versus University of Florida. The driveway permit process is not the forum for challenging that need to wait in traffic, the requirement to wait in traffic. It's not in this proceeding, it's narrow. And someone 4 miles away is far too far away to be affected by the functioning of the connection. And thank you, Your Honor.
Very good. Thank you very much. Mr. Smolka?
Yeah, please. Let me address the argument that these issues were all sorted out for final determination before the local government and before the circuit court. That is not factually accurate. The county conditioned their approval of this particular project on the DOT issuing driveway connection and stigmatization. So they delegated, or at least put it into DOT's corner to do it. In the circuit court challenge, and which I believe the final order is in the record, the court declined to address the issue because of the fact that it wasn't before the court at that point in time, because the DOT had not taken any action. So the court essentially deferred on that issue. So there has never been any kind of final determination with regard to the problems that are created by this particular signalized intersection. I would also like to step back a little bit and let's sort of talk about the umbrella here. The APA presumptively applies to all actions that are taken by the DOT unless they're expressly exempted by statute. They're not. There is no statute that exempts DOT's driveway connection permits from third-party challenge. It isn't. And I think it's important to understand that the court in Gottman v. Department of Education 908-7 1118 pinpoint 1120 stated the act, the APA, presumptively governs the exercise of all authority statutorily vested in the executive branch. And it goes on to say, while there may be exceptions in the APA. Other statutes are construed whenever possible in pairing material with, not as repealers by implication of the Administrative Procedures Act. The appellees are basically arguing that they have that the DOT has an exception from the APA, but that is not consistent with the case law that describes the purposes of the APA. Also, it's important to remember, let's look at 335 in a vacuum, in isolation from the rest of the transportation, which technically we're not supposed to do, but let's do that anyway. The legislature said that their intent here was to regulate access is necessary in order to protect the public health, safety, and welfare, preserve the functional integrity of the state highway system, and promote the safe and efficient movement of people and goods within the state. That's the legislature's statement of intent, and it certainly goes beyond just the design of the driveway. You have to look at the big picture. Now, additionally, I had mentioned to you earlier that the DOT's own rules require them to look at traffic signalization as part of the process. And I would cite to you Florida Administrative Code Rule 1496.005 3C5. And in it, it specifically states that you have to submit a site plan, and it has to show the type of construction on both sides of the road, the median openings, intersections, and traffic signals. It then requires that the connection, location, and design information has to include the location and type of traffic control devices being proposed. And then it then goes on to say a traffic study must be submitted with respect to any application that requests or requires a traffic signal, a new traffic signal. So you can't say that 335 doesn't address the issue of traffic signals. In fact, they're inseparably intertwined with a driveway connection, especially when you're dealing with a highly congested roadway that the DOT itself has recognized has some serious problems. And I think, I'm not sure how much time I have left.
You have about 45 seconds.
Okay. So the one other point that I think is worth making here is, again, getting back to the transportation code. You cannot simply take chapter 335 dealing with driveway connections and then isolate it from the rest of the transportation code. These duties of DOT cannot be separated. And in fact, chapters under the transportation code, which is 334 sub 14, it requires that, quote, the chapters in the code shall be considered components of the total code and the provisions therein, unless expressly limited in scope, shall apply to all chapters, which means 334 dealing with traffic signals has to be construed in relation to 335 dealing with driveway connections. You can't simply isolate them and attempt to avoid the mandate of the Administrative Procedures Act. Thank you.
Very good. Thank you all very much. That concludes this oral argument session of the court. I know we have some students who are here visiting. If they wish to remain in the courtroom and chat for a few minutes, we will exit and then come back in a few moments after the streaming is concluded. So thank you all. We appreciate it.
Thank you.
All rise.